You are listening to The Royal Palace, the podcast where we explain French law and politics to Americans. I'm Patrick.
And I'm Liam.
I've ordered every federal agency to eliminate rules that don't make sense.
It's the usual French talk, stall and surrender.
All scientists, dinosaurs, entrepreneurs, the cultural soul of the nation.
You Americans have given us surrender.
The sense was very evil. Our planet great again.
On our last episode, we introduced listeners to France, her constitution, institutions, and territory.
I like you say her. That's very French.
It's very, what would you call it? Maritime.
it's maritime and or French, yeah.
On this episode, we want to give listeners a primer to French law that will serve as a baseline as we move forward with more specific legal topics. Today, we'll be looking at the differences between the common law and the civil law traditions, the role that European law plays in shaping French law, and the functioning of France's courts.
So let's start with the difference between common law and civil law.
Listeners may know that the American legal system, with the exception of Louisiana, belongs to the so-called common law tradition. But what does this actually mean, and how does it differ from other legal traditions? But first, what are those other legal traditions? Legit question, have you heard of any other legal traditions other than common law and civil law?
Traditional law.
Customary law, yeah.
Customary law, yeah. Yeah, like South Africa is a combination of three, right? Common law, civil law, and customary law.
That's right.
Depending on what ethnic group you're from, which is a cool way to do things. So the first major difference between the French and American legal systems we want to talk about is the different legal tradition. Common law in the case of the US and civil law in the case of France.
So I think this is where we sort of start to get in a bit of trouble, because the actual meaning and moreover significance of what a legal tradition actually is hard to pinpoint. And these traditions, except for remote tribes, necessarily do not exist in a vacuum, right? Like judges, lawyers, scholars all inspire themselves off of what's happening around them, and that includes in other legal traditions. So then what makes a legal practice a tradition? Is it its historical roots, similar to the way in which we classify languages? Is it the characteristics of its practice? Or is it the legal dogma it brings forth? If it's about roots and only roots, then it's hard to see why this distinction is actually relevant, at least for lawyers, since it would have little descriptive force for how the law is actually practiced. Though it is worth noting that civil law is said to have originated from Roman law, while common law is said to have originated from practice in England under the monarchy. If it's about practice, though, then contradictions abound, since, as we will see, many sweeping statements we often hear about these traditions know just as many exceptions as there are rules. Finally, if it's dogma that's at question here, then we would need to prove that religious law and socialist law do not belong to the civil law tradition. However, going down this road risks us classifying legal systems not by their form, but purely on the basis of their content. As an example, the Bolsheviks promulgated laws which greatly expanded the ability of women to divorce their husbands or access abortion, and they also decriminalized homosexuality. Many non-socialist countries would follow suit in the following decades, while in the 1930s, the Soviets would actually go back on these under Stalin. Did this lead Western legal scholars to declare socialist legal tradition as dead? Or more importantly, did this lead Western legal scholars to decide that Western legal systems have become socialist since adopting these social reforms? Of course not. While there's certainly more nuance to be explored there, I suggest that essentially everything is civil law except for what is common law. Frankly, the definition of civil law is so large that it encompasses pretty much all law, with maybe the exception of customary law, which I maintain is generally marginal in its practice.
So basically, us Anglos are weird, and actually the French way is the normal way that basically everyone else uses.
So what are the differences that we can at least discern? I'd say in civil law, legal force comes from legal texts, which are ideally codified into codes. Meanwhile, doctrine and jurisprudence guide judges but do not bind them. In common law, however, case law, as an accumulated corpus, is said to be the source of law itself, in addition to text, so in addition to statute. And these statutes are often not codified.
You do see a major difference if you're reading anything to do with French law, for example, or law from almost any other country in the world besides the US or the UK or other former British colonies, is that like you won't see laws, you won't see court cases referenced as in the same way, right? Like within urban planning, for example, in the US, many of the laws that we cite are court cases. Many of the ways that urban planning works that established what municipalities in the US have the right to do was established by court cases, like Euclid, for example, which is sort of the basis of most modern planning. That was just a court case. That wasn't a law. In France, you'd never see that, right?
So, Liam, what is codification?
Codification is the practice of taking laws, whether of customary, jurisprudential, or doctrinal origin, and turning them into codex. That is to say, a single book or a series of volumes which are said to reflect the state of the law as a whole. And it said that every legal question ought to be resolved within. I mean, as I illustrated this briefly in our first episode, the different codes in France, the different laws that pertain to different realms are actual books that you can go buy. This is kind of true in the US too, in that there is like a US code, but the difference in France is that that code is the law. And laws that are passed normally reference which part of the codes they're amending or adding to. But Patrick, what if the law is silent on a particular matter? Like that's why we have all this jurisprudence in the U.S. That's why we rely on doctrine so much, right? Is that like Congress passes laws and these laws don't account for everything. And it's thought that if Congress did have to pass a law that accounted for everything, that would just be way too much work for the legislative body. And there's always going to be things that come up in real life where it's not clear what exactly the law means by this. For example, let's take the case of like once internet gambling started, it wasn't immediately obvious that was regulated by the federal government under traditional gambling laws, which talked about casinos. And, it was up to courts to some extent to decide in those cases what counts. So how does that work in France or in any codified system?
From the moment in which you consider that the law is an ensemble, there is always an answer, maybe not always a satisfactory answer, but there's presumed to be an answer within the results of your codification. So gambling is either regulated or it's not. Now, the decision of the judge in a given case would not itself create law. Perhaps the judge would conclude that, yes, in absence of regulation, we must consider that it is legal. But that doesn't mean it is forever legal, because the role of the legislature is, at least in theory, to then intervene if it believes that it ought to be regulated.
Right. So the court would say, in this particular case, we're deciding this based on the facts of this case, but that doesn't mean that other courts should do the same. And it's really like it's the legislature's responsibility to keep updating things, as opposed to in the US where we keep reinterpreting 100-year-old laws to mean new things, right?
Right.
Codification feels like, and is generally considered, right, like the defining characteristic of the civil law tradition. But as I mentioned before, there's the U.S. Code, which is, or looks to be, a codification of American law, is it not?
That's right. Common law systems have, in certain cases, decided to go ahead with some form of codification. However, typically, these are less developed attempts compared to what we see in civil law systems.
Right, and that code itself is not binding, right? It's the original statute that's binding. Does this mean that all law is codified in civil law systems?
Absolutely not. In France, for example, some statutes remain uncodified or codified in unofficial codifications. This is similar to perhaps restatements in the United States. But again, we're talking about on the margins. Many aspects of French administrative law, though, were essentially uncodified up until the 2000s, and even still, administrative law remains highly jurisprudential in nature.
Wait, but what do you mean by jurisprudential, and how is that different from case law as we know it in the United States?
Judges in civil law are said not to make law, but only implement and interpret it. But that doesn't mean that jurisprudence doesn't play a role in the actual practice of the law. If, for example, you were to buy a copy of the Civil Code, for example, you would see that there are annotated references within the code. These are made by scholars, and they help to clarify the interpretation that courts or judges have used in order to interpret the law. Sometimes these cases may be merely illustrative. In practice, judges obviously inform their decisions based on these references to jurisprudence, but you'll never actually see this explicitly cited in their judgments.
In common law, you could reproach a judge for deciding on a case in contradiction with established case law. Can you not make the same reproach to a civil law judge?
I can really only speak to this question as it concerns France. When you feel that a judge has decided contrary to like what you would call established jurisprudence, you can you can only reproach them for essentially violating the law or not respecting the law, making an error of the law. If eventually you make it to the highest court on this very basis, it essentially becomes a matter of jurisprudential policy. So in other words, the court will either uphold the jurisprudence or decide to modify it, not in an attempt to create a binding rule or a binding law as such, but rather as a way of establishing sort of more soft law, like a form of guidance for lower courts. It's sort of like internal policy within the court system, if that makes sense.
That sounds a lot like case law, though.
It's true that there are a lot of similarities, but generally speaking, jurisprudence is always going to be subordinate to texts themselves, meaning that there are very few legal remedies without being attached directly to statute. This is different from common law, which knows many legal remedies without text to back them up. So trespass would be an example of this. It's essentially judges which discovered it, if you will, as a tort.
Yeah, and there's a bunch of things like that that are like come from time immemorial within the English tradition, right? That just like have their origins in basically customary English law going back centuries. And in France, you won't find anything like that, right? I mean, you will find stuff that has very old roots in Roman law, but it's all written up. It's all in the little book you can buy. We should sell our own branded civil code translations at some point. That'd be kind of funny.
Yeah, that'd be great. Especially if they were like literal translations, like, the ones that make you do on the spot.
Yeah, they'll do the whole thing as an audiobook where it's just me reading through it for the first time and translating it on the spot. And we'll sell that for $29.99.
So with all that boring stuff out of the way, what do you say we talk about where France fits in terms of international law and European law?
European international law. This is another major difference between France and the US, of course, especially European law. There is nothing you can compare to the European Union that the US is a member of. Like, it's an organization established by treaty, but it's much more than a normal treaty organization like NATO or the Organization of American States or the UN. It's got much more of its actual, it creates law, for one, which none of those other entities do.
When we're talking about the European Union and its law, we're essentially talking about a hybrid, as Liam alluded to. It's essentially a transnational law because it's neither international as we know it, nor is it domestic, right? Because there's still a degree of presumed sovereignty of national governments.
There is a degree of sovereignty, but it's indisputable that all the member states have handed over a significant portion of sovereignty to the European Union, and that includes being subjected to its laws.
Fictitiously, though, they can always leave.
Yeah, as Britain did. It's a bit of a mess, though. It's not so easy, especially if you're part of the euro. If you're part of the euro, leaving would be very difficult.
So, Liam, what are the institutions of this European Union?
I would describe it as having an obscenely complex structure. We'll definitely do an episode at some point where we really delve into that, because it's the kind of thing where I don't know if anyone's surveyed like European citizens asking them if they could explain the basic function of the European Union, but I would guess that people would do very, very badly. I would guess that many actually members of the European Parliament and maybe even a few European commissioners would get some of the basics wrong, because it is organized to sort of look like a normal parliamentary system that you'd see in a country like Germany or the Netherlands, but it's not. There's 4 really important institutions. I mean, there's a lot more, I guess, but the core organizational structure is based around the Commission, the Parliament, and then the mess of councils. I call it that because there are 2 different things called the Council, although sometimes people refer to them as one entity because they're very similar. And that's the European Council. The European Council and the Council of the European Union. That's not to be confused with the third council, the Council of Europe, which is a completely different thing that we'll get to in a moment, isn't part of the EU. So again, I don't want to get too much into the weeds of how this all works, because that's not our focus right now. But you have the directly elected European Parliament, which is one of the 2 legislative bodies. You can think of it as like the lower house. It's the equivalent of the French National Assembly or the American House of Representatives. And that's the only part that's elected in the entire EU. Those are called European elections, and they elect MEPs, and they then form political groupings in the European Parliament. There's then a second legislative body, kind of an upper house, which is the Council of the European Union. The Council of the European Union is a very confusing organization because its membership depends on the subject being discussed. Basically, it has 27 members, and they're the national ministers for whatever formation they're meeting in. So if they're talking about agriculture, it's the 27 agricultural ministers or whatever the member states have decided is their equivalent of that. Ditto for when they talk about the economy, etc. Strange institution, upper house that doesn't have a permanent membership and that meets in 10 different configurations. The fact that there are 3 different major organizations, 2 of which are in the EU, that have the words Council and Europe in them makes me genuinely think this was deliberately designed to confuse people. I really am convinced of that. It's so strange. Again, I feel like if you quizzed MEPs in the halls of the European Parliament about which is which, a very significant percentage of them would get them confused because it's just confusion. Council of the European Union. Anyway, then the Council of the European Union has this thing called the presidency of the Council of the European Union, which is a rotating thing that rotates between different member states. Anyway, every time you try to explain one of these things, you delve into just it. Oh my God. I cannot overemphasize how confusing the European Union is. It inherits tradition not from Rome, but from the Byzantine Empire in terms of bureaucracy. And then you have the European Council, which is part of the executive branch. And the European Council is formed of the heads of state or heads of government, depending on the country, of all the member states. And then it has a permanent president, currently Charles Michel. Then you have the other part of the executive branch, which is another really important body called the European Commission. And that's sort of like the cabinet, that's sort of the equivalent of a cabinet. It has the president of the European Commission, who's generally these days at least seen as kind of the figurehead of the quote unquote president of the EU. That's currently a very charismatic German woman you may have heard of called Ursula von der Leyen. And then you have 27 commissioners who each have a post that's kind of like a ministry. Those are the basic institutions. Now, how those institutions interact to actually form law or do anything is also very confusing. The important thing to know for now is that the least important one is the one that is elected the European Parliament. They definitely have the least power of any of those institutions. I'm sure someone could disagree with me on that, but whatever. The point is the real power is held by the national governments. So despite it being this transnational body that paints itself as being a sort of sovereign thing and does definitely have its own sovereignty, it looks more like a union of states when you sort of do an analysis of who's actually making decisions, which is that the most important things have to be decided effectively by the European Council. The Council of the European Union. Oh no, I'm getting confused. The European Council, the ones that's the head of the state, head of states. They make the most important decisions, right? And then the Commission, which is appointed by the Council with the approval of the European Parliament. Does that make sense? And then you have several other important institutions, of course, most notably the European Central Bank, which is again one of the most important institutions in the EU. The head of that is appointed directly by the Council of Heads of State with absolutely no input from the European Parliament.
Yep.
We'll definitely delve on future episodes more into how each of those things work because it's fascinating. If you love bureaucracy, if you love looking at diagrams, understanding how the EU works is going to be your favorite thing. And I am that kind of person. It's great. I think they should make it more complicated.
So the result of this in terms of legislative production are 2 different things. On one hand, there are directives, and on the other, there are regulations. Directives are just that. They are instructions to member states to implement within their own internal legal regimes specific rules or legal mechanisms that are in line with EU policy. So an example of this might be, say the European Union believes that in order to protect a certain right, there must be a specific legal process that exists in member states, but they're not going to tell you exactly how to do it. They're going to say, well, it's up to member states to decide how to achieve this goal, but the goal must be faithfully achieved.
And what happens if member states don't implement that?
If they unfaithfully implement a directive, then they can engage their liability in front of the ECJ, which is the European Court of Justice. And the same goes for when they violate a regulation. Now, what's a regulation? A regulation is directly applicable law, meaning the European Union will fix a specific rule and it must be applied directly. There's no need to have the intervention of each member state's legislature. Going back to the directive for a second, though, I think it's worth noting that generally speaking, there's a 2-year period to implement a directive. And this means that the parliaments of each member state is expected to, craft their interpretation of what the directive means and implement their sort of administrative structures around its implementation. And that can be either a margin for sometimes even making European policy more effective than the EU or more aggressive than what the EU originally, imagined, or it can be a way of essentially fudging along the lines, right? Like playing ball, but not being entirely faithful to what EU policy is.
Would you say that one of those is more common? Do they pass more directives than regulations?
There are more regulations than directives. Directives are increasingly looking like regulations, meaning they're more and more specific in their nature.
So you mentioned a certain court, which brings us to how this law is applied. So that there's no European court system in like not really. There's no European court in Paris. If someone violates European law, you don't take them to a European court. You take them to a French court, or you take them to a Spanish court. You take them to the court in the country in which it happened. However, there is a quote unquote Supreme Court.
Yeah, so this is called the ECJ, the European Court of Justice, which decides matters of European Union law, and it's located in Luxembourg.
So a brief aside on Luxembourg City, which I've heard only great things about. Well, just to say that the European institutions are overwhelmingly located in 3 cities. Normally, people refer to Brussels as the capital of the European Union, and that's because that's where the Commission is. That's, I guess the Council doesn't have like a actual location, but usually meets there. And that's where most of the most important institutions and things happen, except for the European Parliament, which is technically based in Strasbourg, even though they actually hold most of their meetings in Brussels. And then you have Luxembourg, which is where a bunch of other important but more boring things are located, like the European Court of Justice or the European Court of Auditors, which is not actually a court. And then you have Strasbourg, where they put a few things to keep the French happy.
Hey, don't forget about Frankfurt.
Oh, yeah. But nobody, like when people talk about the 3 capitals of the EU, it's Brussels, Luxembourg, Strasbourg, even though, yes, one of the most important institutions of the EU, which is the European Central Bank, is located in Frankfurt. In fact, that's probably more important than anything that's located in Strasbourg. But Frankfurt does not get the title of European capital of Europe, because I think people would get upset if any of those were in Germany.
European Court of Justice is interesting as an institution because, as Liam alluded to, there's no direct access to it. What does this mean? It means that if you feel that the, say, legislature of France has not correctly implemented a directive or is in violation of a regulation, you can bring that up only in front of the national judge, so the French judge. And you essentially say, hey, you're violating the law, or I believe this violates the law. Now, the national judge can just agree with you outright, and it's as simple as that. But if the answer is not clear, or perhaps the national judge doesn't agree with you, it can instead be referred, the specific legal question can instead be referred to the European courts. Now, this has kind of some issues because, for one, the national judge can just say no. And furthermore, just because the European Union Court, at least in France, says that something is not conform with the law, doesn't mean that the national judge is required to change the outcome of your case.
Really?
Yeah.
That seems like that could create issues.
I think something a lot of people miss when they study European law is just the fact that the fact that there is no direct recourse to the ECJ means that the cases that get there are generally people who are highly motivated and who have the funding and, above all, the time to take a case there, and are often doing so on the basis of some sort of larger principle that they're fighting for, because otherwise, especially seeing as it may not have an actual impact on their specific national case, it just might not be worth it otherwise. So, for example, if you're like a trucking company that really is fighting for some larger principle of free trade in the EU, you might be able to justify going all the way there. If you're just some guy, it probably might not be worth it for you.
Didn't you say that about the Supreme Court in the U.S. too?
I think you could say that about all courts to some extent, to varying extents, and I think that's important, right? Especially when we get into administrative law, we'll talk about like where access to justice really plays a role into as to whether or not it even matters what the law is. With all that said, let's move from European law to international law. So from this point on, I am speaking about international law, regardless of how many times I use the phrase European. So the first legal text of international law that I think is fundamental to law in France and within Europe is the ECHR. So what's the ECHR, Liam?
The European Convention on Human Rights is just like it sounds like, a convention on human rights, but it's not just the EU. This encompasses the whole of the third council that I mentioned, which is the Council of Europe. Now, that sounds like it should be the most important one, but it's actually probably the least important one. So this is a council that covers basically all of Europe. Until recently it did. Currently, Russia and Belarus are both suspended after the Russian invasion of Ukraine. But the point is a much broader membership than the EU does. It includes Turkey, for example. It includes Ukraine. So the Council of Europe is based in Strasbourg, and it does several different things, but by far the most important, and the only one we're going to talk about right now, is the European Court of Human Rights, which gets its authority from the European Convention on Human Rights. And the important thing about this is that this is correct me if I'm wrong, but this is your standard international treaty. This is like with the International Court of Justice. It's not like with the EU. Even though we're talking about something that only applies to Europe, it's very similar to other types of other international treaties and doesn't have anything to do with the EU, is the important thing to remember.
Yeah, so within this treaty, there are references to property rights, there are references to discrimination or anti-discrimination, if you will. But I would say one of the most important, at least from a legal perspective, is Article 6-1, which guarantees a right to a equitable trial or a right to a fair trial, because you often see that being invoked against national practices which are said to not respect the right to a fair trial. What's interesting is that the ECHR, the so-called Strasbourg Court, which is again the European Court of Human Rights, plays perhaps an outsized role compared to other international courts. There are frequently cases brought against France on the basis of Article 6-1 on the right to a fair trial, notably regarding France's strange or perceived as strange administrative law system. But in any case, the jurisprudence of this court does indeed play a role in how French judges will, interpret things. But especially, it can often lead to creative reasoning on the part of notably the Council of State, that will find a way to, on one hand, go along with what the ECHR wants in terms of form, but maybe not in terms of substance. But I'm sure we'll get into all that on another episode. What I think is interesting, and I think this is what changes everything in terms of how international law, or what international law means in France. So the Constitution of 1958, in its Title VI, which is entitled on treaties and international agreements, it holds that the president signs and ratifies international treaties and that they prevail over all else, meaning acts of parliament, except for the Constitution. So the Constitution is the only exception to that principle. Accordingly, international law has primacy over domestic law. And so the parliament cannot go against it, if you will. And so if you're in a court instance, if you bring a case before French courts, you can argue that international law has superiority over national law.
That's kind of a weird concept for Americans, right? That the French government is actually constitutionally required to follow international law and the international treaties it's party to, in contrast with the U.S. government, which seems constitutionally required to not do that.
And also, in the United States, it requires an act of Congress to ratify a treaty. So in France, the president can just unilaterally join a treaty and ratify it, so long as it doesn't involve spending money, basically. Then an act of parliament may be required, but generally speaking, the president can sign France up for whatever he wants. And then that immediately has more power than any jurisprudence in France, than any laws, any regulations that are currently on the books and passed by parliament.
And it also means that, and a number of European countries have this in their constitution, but it also means that you, as an ordinary citizen in France, have recourse against your government if you think it's violating international law, right?
Precisely. But of course, you're going to still be relying, though, on national courts, right? So are national courts always ready to say, oh, yes, no, I think this international law is more important than the law of my own country? That I think is where you see the practice not always lining up with what you see in the Constitution.
Yeah. And again, if you look at the membership of this convention, and Google a few of those countries' human rights violations, you'll see that the effectiveness of ECHR rulings is not It's not as effective as people might pretend it is
Or want it to be.
or want it to be. Yeah. As a slight aside, like this suspending Russia from it, I found to be very strange because surely the whole point of a human rights treaty is that you can then like rule against countries for human rights violations within the context of that treaty. And if you suspend them for violating human rights, I don't get that. That seems strange. Take them out of the jurisdiction of the treaty.
Yeah, I honestly don't know how any of that, like maybe it has something to do with funding.
They just suspended Russia from everything in 2021, I think, and they
Yeah,
suspended
maybe-
Russia from like the lunch voucher program or whatever at the UN. Who knows? They suspended them from It was just like sort of a knee jerk reaction.
So now that we know that France is subject to the will of international law, perhaps we ought to look at how things work internally. So taking a closer look than we did on episode 1 at French courts.
Yay!
So in the first episode, we mentioned briefly how France has a strong division between public and private law, and accordingly, completely separate court systems along these lines. We remarked that France, unlike the United States, has 4 Supreme Courts. As a reminder, these are the Court of Cassation, the highest court of private law, the Council of State, the highest court of public law, the Constitutional Council, the highest court and only court of constitutional law, and the Tribunal of Conflicts, which is the court tasked with settling disputes between these courts, so between the Court of Cassation and the Council of State. And I don't believe I mentioned it on the first episode, but the Tribunal of Conflicts is actually just members of the Court of Cassation and the Council of State presided over by one or the other. So that means that there's always a majority of one side or the other, but it just changes in time.
So there's got to be some fun internal politics going on there.
Well, yeah, I mean, when the Council of State had the majority, they decided more in favor of the Council of State.
Great system.
So let's start, Liam, with the Court of Cassation and its lower courts, which, as a reminder, are the courts of private law.
Doesn't cassation literally mean breaking or quashing?
That's right. The Court of Cassation is named as such because its role is essentially to intervene when lower courts have misinterpreted the law, thus quashing their reasoning or quashing their decision.
That sounds very violent. I'm picturing a big gavel coming down in a lower court building.
There are no gavels in France.
What? You're
Yeah.
kidding me. Man, doesn't that take away the whole appeal of being a judge?
Well, you get cool robes in France.
That's
so
true.
how
The
about
robes
that?
are pretty cool. The
So-
red ones, right? Those are awesome.
Well, that would be in the Cour d'assises.
Well, that's the one I want then. If they make me be a judge, that's what I'll do. And I'll bring my own gavel. They can't stop me.
So, in theory, it is not a court of fact-finding, since this is presumed to have already been done by lower courts. Of course, the Council of State plays a similar role for public matters, but they have a role that is much larger than that of the Court of Cassation, since they are also an advisor to the government and helps them write regulations. So they don't have the same name.
And also the name was already taken.
Good point.
Council of State obviously sounds way more important. Sorry, Court of Cassation.
So below the Court of Cassation are 2 degrees or instances. These are the judicial tribunals and the Court of Appeals. So obviously the judicial tribunals are who you bring your case to first, and only if you're unsatisfied with the outcome do you go to the Court of Appeals. It is once you've gone to the Court of Appeals that you can find yourself at the Court of Cassation. Now, in first instance, you bring questions of facts and questions of law. It's up to the first instance to make rulings on both. Now, once you go to the Court of Appeals, though, you are still bringing questions of fact and questions of law. This a bit different than how it works in the United States, but I want to emphasize just the idea that essentially appeal in France is necessarily a retrial of the case. Now, that doesn't mean that every question needs to be reopened. That doesn't mean that, it doesn't mean that the whole process is the same or that you can just come out with completely new evidence, but it does mean that it's understood as like a full second look at the case and that it's a right that you have. You have a right to a second look at the case. It's not because in first instance, the judge decided these are the facts that the second judge is bound to them. And so this is considered a guarantee, a French interpretation of the guarantee of a right to a fair trial. This is a distinction between the United States where, especially as I understand it, at least in criminal matters, it really is important first instance because when you're going to appeals, you're already kind of in what we would call in France cassation, where you're not supposed to question the facts that the jury decided on, right? Unless there was a procedural issue. which is a question of law. So that's more along the lines of cassation.
So if the judges are responsible for fact-finding, what's the role of the jury?
So juries exist only in the margins in French law. They serve in certain criminal trials, but we're not talking about like you stole a banana from the grocery store. We're talking about like murder. So in most civil law countries, there are no juries for the vast majority of cases. And that means that it's up to the judge. And when we say, by the way, when we say the judge, we're actually referring to a panel of judges in the vast majority of cases. This is because the judges, again, have a greater role in the actual cases themselves, because they not only decide on the law, they decide also on the facts. But they can also have a role in the actual investigation, meaning the judges can force parties to produce different evidence that they themselves have decided might be relevant for the facts. Now that it varies. So in private law, it's a little bit more restrictive, the extent that judges play a role in this, but nonetheless, it's kind of them that set the pace. It's not like in the United States where you have this very long discovery stage, a lot of preparation for a trial, right? Because in the US, you're relying on this like really short window of time where you need to present everything to a jury because you can't keep the jury for several months. In most civil law jurisdictions, like a civil trial can be broken up into many stages.
So that's the private law side, right? That's the civil law. Let's talk about public law, administrative law.
So historically in France, it was just the Council of State. Now you can imagine this is a bit silly in certain circumstances because remember, France extends all the way to French Polynesia, which is on the other side of the world. And indeed, there are still certain cases that have to be brought directly to the Council of State, which means that you have to fly to Paris.
Not cheap from Tahiti.
Luckily, though, things have evolved in a few ways. For one, we have now, just like in the private system, two lower instances. So there are the administrative tribunals at the bottom of the pyramid, followed by the administrative courts of appeals. This reflects the private system in the sense that you do get two tries in most cases, but there are a lot more exceptions because, as I said, certain things must go directly to the Council of State. Others must be brought directly to appeals courts, and the rest are brought in first instance to administrative tribunals. However, in certain cases, it's actually the administrative tribunals that decide in first instance without an option for second instance, and you go directly to the Council of State after. So it's a bit more complicated, but the general schema remains the same, if you will, which is two instances followed by cassation.
And I think it'd be useful to back up a second. We did talk about the difference between public and private law in the first episode, but I think it might be great to just spit off some examples because people are picturing these two different court systems with these two different Supreme Courts at the top, the Court of Cassation and the Court of State.
Council of State.
The Council of State, sorry. Let's make this more concrete by I'll throw out a couple types of things and you tell me which system this would go through.
Sure.
So first of all, okay, let's say an eminent domain case, right? The state wants to take some of my property in order to build a new road, and I think that they're overstepping their legal right to do so.
So a case like that actually is divided up between both the private and the public jurisdictions. On one hand, there's an administrative process, right? This is the process in which the government's going to identify what land to expropriate and then is going to make the administrative decision to actually expropriate the land itself. And so that is a question. Both those questions are questions for administrative courts only. However, once the government has decided to expropriate, there is a question of compensation, and that is handled by the judicial judge or the private judge, because France is not a socialist republic. And even when the government expropriates, it's supposed to pay a just compensation, just like in the United States, for what it has taken. And it is considered that an administrative court is not the right place for that, since they are obviously going to have the interest of the administration in mind in deciding how much someone deserves. So that would be a question for the private judge. However, if the government essentially is just abusing its power, right? Maybe it doesn't like you, or it wants to take your land for the purposes of then reselling it to your neighbor who is actually a really important person in government or whatever, that also would be something that the private judge would be competent for. Because we say in France that the private judge is the guarantor of individual liberty.
What it sounds like from that is that the line between them is not quite as clear as you might think. Just because something involves a public body doesn't make it public law.
That's right. And sometimes there is no obvious private body involved, and it is nonetheless a question of the public law courts.
Another example that might not be clear. So, I mean, we can give some really clear examples, like I'm suing my neighbor over the noxious fumes that they're letting off into my house. Private law, right?
Yep.
Makes sense. Dispute between two private individuals, the state is involved. Private law.
Unless your concern is that the government hasn't done what it's supposed to do, right? Which is enforce. I mean, if it's toxic fumes, we might be talking about a regulated industry, or we might just say, hey, the government's not doing its job in enforcing the law, which is you can't release noxious fumes from your house into someone else.
Yeah.
So there's definitely what we call a degree of administratability there. But yeah, generally that classic disputes between neighbors are concretely the concern of private courts that fall under the Court of Cassation jurisdiction.
Another one that seems public to me. I've been hit by a police car in what I believe is reckless driving by the police, and I want compensation.
That is an interesting question.
I thought that was going to be a clear-cut one. Damn, nothing's clear-cut in the law, is it?
First of all, you bring up a car accident. That is by decision of the legislature under the insurance law that was passed in the 80s. And so that question, while before that law would be a question of public courts because it involved a public vehicle, is now exclusively a question of private courts.
Oh, just because it's a car. What if I was hit by a police horse? I was trampled by a police horse.
Now that would be an interesting question because...
Oh, no.
So in what context were you trampled by the police horse?
I was in the park. Those ones you see in Paris, the Republican Guard, I think they are, who walk around ride around their fancy uniforms on their horses. The guy recklessly rode his horse through the gardens of Luxembourg and trampled my foot. I want compensation.
So in that case, the police officer is doing what we would call an operation of administrative police because they are doing essentially preventative policing, right? They are not chasing a suspect, and you are not the suspect, but they are instead just present doing a patrol in order to maintain order. And so you were hurt in the course of that operation, which is an administrative one. In that case, you would definitely be in front of an administrative court.
Now, what if I was injured by the French train company, SNCF, which is entirely owned by the French government? Okay, let's say I'm taking a train, an SNCF train, and I lean against the doors, and they unexpectedly open, and I fall out of the train, and I'm gravely injured.
That is a question of private law because you have a contract with the train company, which is operating as a private operator, and it is a private company.
It didn't used to be until it's only relatively recently been a private operator.
Even still, that would be a question for private law because essentially, like SNCF has always operated, in a way that's sort of similar to a private company.
Mm-hmm.
It's not the same thing as for example, when you buy a train ticket, you're generally paying for the service rendered, even though obviously I think public entities are much better at running trains for various reasons. A private company could do it.
Mm-hmm.
Not everyone's going to deliver you a passport, right? Not everyone's going to make you a passport. And, that's considered a very administrative service as opposed to a commercial or industrious service, right?
So I think what we're learning from this is that the distinction is not immediately obvious, confusing.
Let's try a few more examples because I don't know how all this is going to work out in editing.
Well, one I of course want to do is a criminal case. Yeah, I've been arrested for robbery. That doesn't seem private, right? It's a conflict with the state. So
criminal law doesn't fit in very well with the classical private-public law distinction, but it is very much about liberty, right? It's about whether or not you get to enjoy or be deprived of liberty. As a result, even though it has some public element to it, in the French court system is a matter left to private law. Within that system, it does have its own courts, right? You're not going in front of the judicial court. You're not going in front of the judicial tribunal. Instead, you're going in front of a special court in function of the kind of criminal act you committed.
Let's say I've overstayed my visa in France and the state wants, the police arrest me and they want to deport me and I want to dispute it.
Administrative courts.
Okay, I run a a boutique coal mining company. I have 3 employees, and we have a little coal mine in my backyard. It's a very classic French small business in the Parisian suburbs. And the state has just released new regulations, the environmental ministry, that make what I'm doing illegal. And I think this is a violation of French law, and god damn it, it's a violation of my rights as a man and a citizen.
So a case contesting environmental regulation, or any regulation for that matter, is brought before administrative courts. However, in this case, it would be brought before the Council of State directly. You wouldn't be able to go to an administrative tribunal and then a court of appeals if you wished to finally get to the Council of State at the end.
Why is that? Regulations can only be disputed by the Council of State, or?
Yeah, they can only be brought before the Council of State because they're considered to be essentially of such matter of importance that it's best just bring the whole case to the Council of State, and it can just decide right there and then. It eliminates so much legal uncertainty because the Council of State can probably bring you a decision within 9 months, maybe even less, depending on how important this regulation is, and then it's case closed. No need to litigate this for 4 years.
But that's because of the national government. What if I think my municipal government is overstepping the bounds of the law in something they're doing?
So remember that local governments cannot promulgate regulations, but they can use police powers.
Right. So my city is using its police powers in a way. They're putting these goddamn écolo bike lanes everywhere, and I think that's a violation of the traffic code or something.
Right. That would be brought in front of administrative tribunal. Sort of behind all of this about administrative courts is the Council of State. And I cannot understate what an important institution this is, because as we mentioned in episode 1, it serves a odd dual purpose. On one hand, it is advisor to the government. It is supposed to review and help with the sort of technical redaction of regulations. And on the other hand, it is a court. Now, you might be thinking, that doesn't sound like a fair trial to me. The people who helped write the regulation are also the same people who are going to decide whether or not it's legal. This duality might seem as a violation of the right to a fair trial. That is, again, under Article 6-1 of the ECHR. France isn't the only country to have this duality. In fact, Luxembourg has a Council of State. The Italians as well have a Council of State. And so the legality of this dual function was challenged in the case of the Luxembourg Council of State. And it was decided by the ECHR that the duality itself is not illegal, but it would be illegal for someone who has already participated in, say, a rulemaking process to then find themselves on the other side as judge. Mm-hmm. So essentially, yeah, there's a question there, or there can be a question there, but so long as it's not literally the same people, it's considered legal from the perspective of the ECHR. With that said, though, it is still the same organization. These people talk. There's a certain collegiality, as we call it. Yeah. Is that how you say it in English?
Yeah, and that sounds obviously, from an American perspective, it sounds really weird, right? It seems to violate our basic conception of a separation of the branches of government. But the thing is that France just doesn't really have that as a principle, right?
Yeah, at least not in the same way.
De facto, it exists to some extent, but it's not this defining principle that we tend to make it in American constitutional law.
I think it's worth noting that the Council of State is a highly productive organization. I mean, they process thousands of cases a year. You compare that to the Supreme Court, which outside of the shadow docket averages around 78, I believe, a year. And with that said, France is a much smaller country. As we also said on episode 1, the Council of State is not 9 judges. Instead, it's a college, as they call it, which just means essentially there's many judges.
There's 231, to be specific right now.
This principle of collegiality is a fundamental principle of French administrative law. And it essentially comes down to this idea that there isn't a single judge. In most cases, in the private and public system, you're going to have a panel of 3 judges for every case. Again, there's going to be exceptions, notably for emergency procedures. There, it's a single judge. But when we're talking about deciding on the facts of a case, you're going to have a panel. And that's supposed to be a protection or a safeguard to ensure that, the will of one person can't affect the outcome of your case. And this also comes back to this idea that law in France is sort of abstractly in the name of the people. I say abstractly because there's no room for dissenting opinions, right? The court decides as a court, and it does so in this very abstract way in the name of of law itself, of the people. And so you just don't see this kind of same, in terms of decisions, you don't see this kind of same like a push and pull of justices who disagree. You don't have dissenting opinions, as I said. I think there's some fictitiousness to this because, of course, the judges disagree. Of course, there's debate. Of course, it might give you the wrong impression that there is only one way to interpret a law, but it's nonetheless, I think, an important distinction between the French and American legal systems.
And one more thing about the Council of State. Where is it based, Patrick? Where is it located?
It is based in the so-called Royal Palace.
The Royal Palace.
In the center of Paris.
Le Palais Royal. The namesake of our podcast, which I think we mentioned on episode 1.
No, we didn't.
We should have. Anyway, that's why we're called that.
Yeah, in case you were wondering.
Look it up. Cool building.
So that was a basic introduction to French law. If you happen to be an expert in French law, I'm sure you're angry that we didn't cover in enough detail some very important topics, but why were you listening to this episode anyway? And then for those of you who are just utterly confused about what the hell we just talked about, I'm hoping that in future episodes, this will all become more clear. But if you have any specific questions, feel free to reach out to us.
Please get in touch. You can message us on Twitter or on Reddit, or you can email us at questions@royalpalacepod.com.
La France est une chose, à mes yeux, très considérable. Je me fais en effet de la France une certaine idée. Je veux dire par là qu'à mon sens, elle est quelque chose de très grand. Je me fais en effet de la France une certaine idée. Il y a même là quelque chose d'extraordinaire. Je me fais en effet de la France une certaine idée. Il faut que la France joue son rôle, c'est exact. Et pour qu'elle joue son rôle, il faut qu'elle soit la France.